Let's go to the statements that are out there from Brandon Miller's own attorney. Again, let me make this clear. This is Brandon Miller's own attorney. This is their press release that they put out last week. The headline of that is Facts Surrounding Brandon Miller's Presence at Scene of Shooting on January 15th. Okay? This significantly is not the state of Alabama. This is not the prosecuting attorneys. This is not the DA. This is the defense attorney of Brandon Miller. That is, this is the individual who is putting Brandon Miller's behavior in the best possible light. This is important. This is his job. I've been a criminal defense attorney before. I understand the responsibility. It is to put your client in the best possible position. I'm not going to read the whole thing, but I do want to contextualize it for you. This release is occurring because, quote, I want to provide additional facts on Brandon's behalf regarding misstatements. All right. Brandon didn't go inside the nightclub. All right, but let's go back up here. This is the second paragraph. Mr. Miles brought his legal handgun. Well, let me just read this whole paragraph. On January 14th, Brandon played in a basketball game in the afternoon and later was asked by Darius Miles for a ride to the strip area to go to a nightclub. Mr. Miles brought his legal handgun and left it in the back seat of Brandon's vehicle. Brandon never saw the handgun nor handled it. Further, it is our understanding that the weapon was concealed under some clothing in the back seat of his car. Again, Brandon never saw the handgun and he didn't handle it, and it was concealed under clothing in the back seat of his car. What is significant in this paragraph is what isn't being said. There is no allegation here that Brandon Miller didn't know there was a gun, right? It's just saying he didn't see the handgun and he didn't handle it, and that the weapon was under clothing in the back seat of the car. In other words, Brandon Miller knew there was a gun in the car. Again, if he didn't know there was a gun in the car, his attorney would say explicitly, Brandon had no idea there was ever any gun in the car. He doesn't say that, okay? Let's continue. Brandon didn't go into the nightclub. Instead, he went to a restaurant to eat. At approximately midnight, Mr. Miles began asking Brandon to come pick him up so they could leave and go to another location and join friends. Brandon advised he would be along later. Approximately 1 hour later, Brandon began to leave the restaurant to go pick up Mr. Miles. First, he had to give another companion a ride home. Again, I am reading directly from the defense attorney statement for Brandon Miller. Before Brandon arrived to pick up Mr. Miles and the individual with Miss Harris apparently exchanged words without Brandon knowing any of this context. And as Brandon was already on the way to pick up Mr. Miles texted Brandon and asked him to bring his firearm. So, the attorney for Brandon Miller is specifically acknowledging that there was a gun in the car, that Miller knew there was a gun in the car, that Miller received a text message asking him to bring that gun to an individual who was involved in an altercation. All of that is undisputed from Brandon Miller's own attorney's statement that is designed to make Brandon Miller look the best possible. So people out there who are arguing, oh, Brandon Miller didn't know there was a gun in the car. According to his own attorney, they haven't argued that. Brandon Miller, he was driving. He didn't get the text message. Well, Brandon Miller's own attorney says that he did get the text message. Okay? And then he says, again, Brandon, I'm reading from the statement, Brandon never got out of his vehicle or interacted with anyone in Mrs. Harris's party. He was never involved in a verbal altercation with Cedric Johnson or Mr. Davis. Brandon never touched the gun, was not involved in its exchange to Mr. Davis in any way, and never knew illegal activity involving the gun would occur. This is the entire statement of that you can go read yourself, but it ends with Brandon does not own a firearm, never handled a firearm, no knowledge of any intent to use any weapon. He's cooperating as any citizen should who's witnessed a serious incident. Okay. Submitted to multiple interviews, law enforcement, all these things. Volunteered to have his phone contents. All right, all of that stuff. Okay? So it's important to understand when you are involved in a legal proceeding, what is fact, what is disputed, could be fact or fiction, and what is still to be determined, right? So I'm only focusing on what Brandon Miller's own attorney acknowledges and what the state's attorneys, what the DAs in Tuscaloosa have said. Based on this, it is undisputed fact that Brandon Miller drove his car with knowledge there was a loaded handgun in the back seat to a corner in Tuscaloosa to deliver that gun to his teammate who had demanded it because he was in an altercation and needed his gun in order to have protection. Okay? So Brandon Miller knew that the gun was in his car, and he knew that his teammate needed the gun because there was an altercation involved. To me, that is reckless and negligent behavior. That is criminal in nature. He delivered the murder weapon to the scene of the murder. If Brandon Miller had simply said, hey, get an Uber, get a ride with somebody else, I'm going back home, I've got your gun in my car, you've been drinking, you don't need to have a gun, stay out of trouble, we're having a good year, that mom would still be alive. That's the reality. That is the facts. These are undisputed facts now. Reading both Brandon Miller's statement and what was said by the attorneys who are involved in this criminal case, right? In the hearing that happened last week. So let me take it outside of this case. Typically, a crime requires two things. It requires both an actus rea, that is an actual act. Brandon Miller driving the gun to the scene of the crime would be an actus rea. And it requires a mens rea, which is an intent. That's why the lawyer here says, well, there was never any knowledge that this gun might be used in a criminal fashion. I would argue with the attorney there, and I would say, hey, if somebody texts me and says they need a gun because they are angry at someone else and it is 1:30 in the morning, my expectation is that's not good, right? Criminal activity might follow based on the information that Brandon Miller received. In fact, it's downright likely. If the text message to Brandon Miller had been, hey, I need my gun, it's noon, and we were planning to go skeet shoot on a farm, that's a different text, right? Then you transport the gun. You're not thinking that it's a violent act, all right? Which is why, to me, again, actus rea, mens rea, but is a typical crime. Many crimes actually do not require the intent to commit a crime. Let me give you an example. You are driving along the road in your car. You are driving too fast. The road is windy. You get a text message. You look down at your text message and decide to respond. While you're doing that, the way that the road winds, you didn't stay in the center of the road and you veered out and you hit a biker or you hit a jogger on the side of the road and you killed him. You didn't intend ever to do that. But arguably your rate of speed, in conjunction with the fact that you got a text message and decided to respond to it, was negligent in such a way that you could be charged with a crime. That, to me, is what Brandon Miller did here. He behaved in a negligent, reckless fashion when he delivered this gun to a street corner in Tuscaloosa to maybe a drunk guy. The guy who actually did the shooting said he was blackout drunk, that he doesn't even remember it because he had drank so much tequila. I think it's reasonable to presume that your teammate might have been drinking as well. And certainly when you're demanded a gun because you're in a confrontation and you need a gun, it's not crazy. It's not rocket science to presume that that gun may be used in a violent fashion. And then, oh, by the way, when you pulled up, somebody came directly to your vehicle and got the gun. You didn't try to stop it. You didn't say, no, dude, let's get out of here. I mean, there are a lot of details we still don't know, but the undisputed facts that we do know from both parties, to me, show negligence and recklessness. Okay. So, to me, that is enough for Brandon Miller to be charged with a crime. In fact, he should be charged with a crime. What I think may well be happening here is, if you read this statement, Brandon Miller may be testifying as a witness against Darius Miles and his friend in this murder trial, because it says that he witnessed it all and there's a camera. And the state doesn't want to say that yet because they don't want Brandon Miller to become potentially a target in this case if they understand that he is one of the prime witnesses for the state. That's my theory. Don't know that to be true, but it would seem to add up based on some of these details. What would Brandon Miller be testifying to? We know that there was around 11 or 12 shots fired. 8 by Darius Miles' friend with the Darius Miles gun, and several more in response to that. What is Darius Miles and his friend's defense going to be? I can almost 100% guarantee you that they are going to argue self-defense. Their defense is not going to be that there's not a dead body or that they didn't commit the crime by shooting that person, this mom, right? There is a dead body. The bullets in her body came from their gun. They did it, right? That's a signed, sealed, delivered. There appears to be video evidence even that they did it. Their only defense in that respect, then, is that they were trying to defend themselves. So what would a self-defense claim look like? Well, an easy claim for self-defense is somebody shot at me first and then I shot at them back. I was not the initial aggressor. Brandon Miller could theoretically testify as to who fired first. And if he is testifying to that, he's theoretically testifying against Darius Miles, his teammate, and Darius Miles, his friend, and saying they are guilty of murder. Now, the Darius Miles defense could still be, well, they flashed their weapon. We thought they were going to fire. They pulled their weapon. We just pulled the trigger first, right? All those are self-defense claims. But Brandon Miller, based on being physically present at this scene, I think there's a good chance that he has turned state's evidence and is avoiding prosecution because he's testifying against these other two guys. Okay? That's my theory of exactly what's going on here. Now, none of this changes the fact that Brandon Miller should not be playing for the University of Alabama. We can argue about where the line is for suspension or expulsion. If you bring a murder weapon to someone who is a student at the University of Alabama and they use it in conjunction with their friend to kill someone and to spray 8 bullets into the night just off campus, you shouldn't still be a student at Alabama. Whether you play basketball or whether you're a chemistry or whether you're an English major. You don't deserve the privilege of being a student anymore. And that's why yesterday when I was saying, Jay Billis did his best to bollocks all this up to confuse people. There's a difference between your rights as a criminal defendant or a citizen of the United States as it pertains to due process in criminal charges and your opportunity and privilege to represent a university in extracurricular activities, right? Being a basketball player is a privilege. It isn't a right. If it were a right, then you'd never be able to be suspended, by and large, for team violations, okay? When you look at all the facts, and I don't even know how many people in sports media have done what I just did, right? Look at the Brandon Miller statement, analyze it, consider not only what is said, but also what is not said. Look at the undisputed facts that are at play here. I don't think this is a remotely difficult decision. The University of Alabama should not be playing Brandon Miller. I don't even think he should still be allowed to be enrolled at the University of Alabama. And I would say that for all the Bama fans out there, if this was the University of Tennessee or the University of Kentucky or the University of Florida or LSU or any other SEC school. And I have always done this. Look at the facts, analyze them, use my best judgment to explain what they mean and what should happen going forward. So that is probably the best detailed description you'll actually have of all of the undisputed facts in this case. And I just want to point out how few people are even capable of analyzing the case, right? This is not something that sports media is designed to do. Most members of the sports media struggle to figure out whether there should be an assist credited to someone or not on a pass in a basketball game, all right? The average sports media member is not also going to have any kind of legal knowledge surrounding criminal-related affairs, okay? That's normal. I do, which is why I'm right and why most Bama fans that are trying to analyze this are completely wrong. You can also be like, oh, where did Clay get questioned? I did the Next Round Live today. I went on with them for a half hour and answered every question they had. And again, focus on the undisputed facts. If there were disputed facts here, by the way, I would have a different opinion. There are not undisputed facts as it pertains to this case, what I just ran through. What would a disputed fact be? If Brandon Miller was arguing he didn't drive the car there. If Brandon Miller was arguing, oh, I didn't have my phone with me, I never even knew that I was being texted. If Brandon Miller was saying, oh, I never knew there was a gun in the car at all. He's not arguing any of those things. He knew there was a gun. He got a text. He drove it to the scene of the murder. That's undisputed. Okay? That is way past enough to get him kicked off the team and, frankly, kicked out of the university. And that's why I put the ultimate blame on the University of Alabama president, who I think is a coward here. And I don't even know what kind of decision-making capabilities he has, but I know he's a coward. And I know that he's making the worst decision possible for the University of Alabama.